Please be seated. This is the time set for oral argument in 1 CACV 20-0330, SOCAA versus DTT ACC. Council, we've read your briefs. We've discussed this matter in conference this morning. This is the time set for argument. I would remind you of that fact that we have, so if you could direct your remarks to our questions and anything else that you would like to make. When you are approaching please remain seated so that we can record it. Before you start to speak, if you'd please announce your name and the party to whom you represent. And I would remind counsel for appellant that if you want to have any time remaining for rebuttal, that's up to you to make sure that you've budgeted your time appropriately. And with that, you may begin.
Thank you, Your Honor, and good morning. May it please the court, my name is Daniel Chamel. I represent the appellant and cross-appellee, Sedona Oak Creek Airport Authority, or SOCAA for short. Your Honor, I would like to reserve 4 minutes of my time for rebuttal, and I'll just get right into it. Your Honor, I'd like to focus today on 3 key points, each of which are independently dispositive and require reversal of the lower court's grant of summary judgment. First and foremost being the issue of subject matter jurisdiction. Quite simply, Your Honors, this case is not supposed to be here. There is a very clear procedural framework set up by Congress and delegated to the Federal Aviation Administration through the Secretary of Transportation to enforce the provisions of the Federal Aviation Act, including the Anti-Head Tax Act, which is the basis of Dakota's cross-complaint in this case. How it's supposed to work is a party that's aggrieved by an alleged violation of the Anti-Head Tax Act is supposed to resort at the first instance to a complaint to the FAA via 14 CFR Part 16 or Part 13. This is a procedure that Dakota is familiar with, as a Part 16 action has been pending since November of 2017, less than a month after this case was initiated by SOCAA's complaint. Notably absent, however, from their Part 16 complaint is any reference to the Anti-Head Tax Act. Instead, they decided to bring this in the first instance in the Arizona State Court, which is improper given the preemptive federal authority over matters regulating airspace and air commerce. Once the complaint is submitted to the FAA, the administrator has broad authority to enter orders.
Can we break that down just a little bit?
Certainly, Your Honor.
I thought you brought an action to enforce rents that you believed were due.
Yes, Your Honor, that's correct.
Okay, and can't they? And isn't it appropriate for them to defend that action brought in state court, which is appropriate? That what you're attempting to do is enforce an illegal provision in the lease.
Your Honor, it may be true that they can use it as a shield to defend against an attempt by.
Well, that's why I
SOCAA.
said let's break it down.
Sure.
So you have no problem with them using it as a shield, to use your term, to defend against the state action to collect rents, as you viewed them.
Your Honor, I don't know that I'd go so far as to say I don't have a problem with it, but there at least is an
Well,
open.
you have an argument on why it might not be a head tax, but you don't have any problem with them being able to defend it in state court.
I suppose, Your Honor, it could be asserted as an affirmative defense, yes, and if pled and proved properly, which I don't believe it was here. I don't believe that was included in their answer, but in any event, I suppose if it were pled and proved, then it could conceivably operate at least to protect them from any charges that may be in violation of the Anti-Head Tax Act. There are no cases on that point, Your Honor, but the purpose here for this appeal is that Dakota goes a step too far in using it affirmatively as a sword for a counterclaim which will not lie and would not lie in the first instance had it been brought originally as a complaint against SOCAA for an alleged violation of the Anti-Head Tax Act. And so, again, Your Honor, to bring it back to the proper procedure here, they were supposed to bring this in the first instance to the Secretary of Transportation. The Secretary of Transportation may initiate investigations, it may adjudicate, and it may even bring an enforcement action if one of its orders is not being followed. But in nowhere in the Federal Aviation Act or in the Anti-Head Tax Act in particular is there an express grant of a right of action to a private party like Dakota to enforce the Anti-Head Tax Act. Quite to the contrary, Section 46110 provides a direct review to the Court of Appeals either in the Ninth Circuit or in the District of Columbia Circuit. That's the only time and the only manner in which a private party may bring a claim arising out of the Federal Aviation Act generally or the Anti-Head Tax Act in particular to any court. They can't even bring it in the district court. So it's preemption, and it's preemption specifically to the courts of appeal. And where you have a direct review statute, like 49 U.S.C. Section 46110, that review in the Court of Appeals is exclusive, absent extraordinary circumstances, which are not present here, and it preempts the original jurisdiction of state courts as well as federal district courts. There are numerous cases on that point. I will direct the court specifically to City of Rochester versus Bond. That's a District of Columbia case from 1979, 603 F. 2nd 927. Now, the private right of action issue, I'm sorry.
No, and I don't want to get you off course, but there are some questions I have about the record that I'd like you to at least to address.
Of course, Your Honor.
You made a statement in your briefs that this whole rent head tax issue was put in the lease at the behest of those individuals that were leasing at the airport. Could you tell me, was there a diminution of rent to once the fee, I'll call it a fee, was included, or was it just a continuation of the rent and the fee was added on top?
Your Honor, I would say that they're both part of the rent, and the reason that I say that is there are two rent provisions.
Okay, you're not listening to my question.
I'm sorry, Your Honor.
Was there a diminution of rent from the first lease to the lease that included the fee? You said, okay, in your brief you said there were lease, and then we changed the manner in which we collected money. And I want to know, from lease A to lease B, how did the structure change?
I understand, Your Honor, and I apologize for misunderstanding your question.
No, I was probably not clear enough.
It's a good question, Your Honor, and I'm trying to reach back into the declarations to recall if that was addressed. I don't know that it was. I do know that I believe the first written lease agreement between SOCAA and Dakota was entered into in or around 2012. I believe that was the first written lease, and that written lease would have had the two rent provisions, or the rent provisions that we have today, which are the fixed rent, which the declaration submitted in our post-trial motion shows is not sufficient to allow the airport to operate in the self-sustaining manner as it's required to. So really, it's not rent plus. It's both the commercial activity fee and the fixed rent are part of the rent.
I understand that you're arguing, but is there anything in this record that would tell me what was the rent prior to this arrangement? I couldn't find it, so that's why I'm asking the question.
I suspect, Your Honor, that there's not. I don't remember addressing that issue specifically, and I don't remember that being raised in any of the declarations or in the set of facts that was submitted to the trial court. So I apologize, Your Honor, but I don't think I have an answer for that.
Okay.
But getting into the rent itself, and this brings me to my second point, is that even if the trial court had the authority and the subject matter jurisdiction to adjudicate this case, it erred here by concluding that the commercial activity fee violates the Anti-Head Tax Act because subdivision E2 of that act expressly authorizes states and political subdivisions like SOCAA to impose reasonable rental charges. And that's exactly what this is. It's a part of the rent. We have here not something that was adopted unilaterally by a state or by a political subdivision that imposed a fee or imposed a head charge. That's what the cases and the statute have all been designed to address. Recall that the Anti-Head Tax Act was adopted in 1973, less than a year after the Evansville decision. In that case, the Supreme Court authorized, it allowed under the Commerce Clause, a state or political subdivision to impose a $1 fee as a matter of law. Just pass the law, pass the ordinance. Every in-plane passenger now has a $1 fee on their head assessed. Congress did not like that. Congress passed the Anti-Head Tax Act, and I think it's worth noting, Your Honors, that it's the Anti-Head Tax Act, not the Anti-Gross Receipts Charge in a Lease Act. Congress was very clear in adopting this statute to circumvent state authority which would in effect balkanize the system of transportation that we have, contrary to the preemptive and unified regulatory scheme adopted by Congress that's been in place basically since flight has begun.
Is there a question that their increase in revenue would not be in line with an increase in how many people are using Dakota's services for flights? I mean, that's where their revenue comes from, correct? Is passengers and how much they're paying.
That is where the bulk of their revenue comes from, Your Honor, yes. However, they do also operate a concession stand and do generate some revenue that way in selling things like food and drink, selling things like souvenirs. So it's not derived entirely from air commerce.
But concessions are specifically exempted under the Anti-Head Tax Act, correct?
I believe that's correct, Your Honor, yes. It is one of the types of fees that is expressly exempted. So the E2 exemption that's at issue, I believe here, is reasonable rental charges, landing fees, and other service charges from aircraft operators for using airport facilities. And that is exactly what we have here. We have a reasonable rent, and there's no dispute that the charges under the lease agreement are reasonable. That's never been Dakota's position. So we have reasonable rental charges for an operator of the airport, Dakota here, that unquestionably uses and operates aircraft from the airport facilities. And this is something that was not fully addressed during the summary judgment proceedings, but was addressed during our post-trial motions for relief, and that is the federal grant assurances. So we're not dealing with just any entity here. We're dealing with an airport that is subject to federal obligations. Once it accepts federal grant money in the form of the Aviation Improvement Program, it makes several promises to the federal government, not the least of which being that it will operate its airport in an economically self-sustaining manner. And the evidence before the trial court in our Rule 59 motion shows that the fixed rent alone, which Dakota would have this court just read in isolation as being the only provision of rent, is not going to be sufficient of a charge to allow the airport to operate in a self-sustaining manner, given the use and given the wear and tear caused by Dakota's operations.
Wouldn't it be easier for us to make that assessment if we knew what the rents were charged before the fee was imposed?
I suppose it would, Your Honor, yes. And I think the fact that that question was not addressed below and was not put before the trial court leads into the third point, which is that this factual record, at a minimum, if the court disagrees with my position, that one, the courts of Arizona and no court really can reach this question in the first instance due to lack of subject matter jurisdiction, and if two, this court disagrees with our assessment that what we have here is part of the reasonable rental charge and is therefore expressly authorized by the Anti-Head Tax Act. At a minimum, those lingering questions, Your Honor, do raise the point that there are at least competing inferences based on the record before this court, based on the record before the trial court, that would render summary judgment in Dakota's favor inappropriate because there is this universe of other facts that simply, due to prior counsel, were not properly put before the trial court at the time of the summary judgment. Getting back to the nature of the charge.
Let's talk about that for a minute. Is it, counsel stipulates to facts, they stipulate to facts all the time. You really want us to hold that there has to be a personal determination by the party before a counsel can make that tactical decision on whether or not he or she is going to stipulate to facts?
Your Honor, I don't necessarily think this court needs to reach that holding because the Arizona Supreme Court already reached that holding in Garn v. Garn. What we're dealing with here is an impairment of a client's substantial right in a cause of action in particular. And here we're dealing at a minimum with a forfeiture or at least an impairment of SOCAA's ability to assert the affirmative defense of estoppel, which are those additional facts showing that the lease agreement was in fact negotiated in this manner at arm's length by Dakota and at the request of Dakota and other operators to allow them flexibility to absorb the economic downturn during the low season of the tourist times and at the same time be able to maintain and pay their rent. That's a fact that goes directly into an affirmative defense that was asserted in answer to the counterclaim and that based on these stipulated facts simply wasn't fully fleshed out by counsel. So I do think, Your Honor, that yes, that is an impairment of a client's substantial right that did require communication with the client, and that simply did not happen here, as evidenced by the declaration of Pam Fazzini submitted.
So does the stipulation itself, I mean, you stipulate, but no one was preventing your client from also having additional statements of fact that they could have filed. I mean, the idea that they stipulated to what the basic 9 statement of facts were is one thing, but the fact that they didn't affirmatively, they had every opportunity, even outside of saying we're stipulating to the facts that were presented by Dakota, they didn't on their own give their own statement of facts to go along with the response to the motion for summary judgment. So what are we to do with that?
I think there's two things. Number one, admittedly, that was an error by prior counsel, as we've articulated in our briefs, and I won't belabor that point here. Those additional facts should have been presented, and they weren't. I do agree with Your Honor that there was an opportunity to do so, but counsel, without client input and without client permission, simply ignored that opportunity and went ahead with the facts that were presented by Dakota. But the other point to that is that I think it's worth taking a look at what the stipulation actually says. Because the stipulation, even if we ignore the other facts that are lingering out there, the facts on estoppel and the grant assurances and all these other facts that could be developed on a further factual record if this is reversed and remanded, the stipulation itself provides that, let's see, apologize, Your Honor.
It's pretty bare bones.
It is pretty bare bones. So what's in the stipulation is, one, the lease, which is totally fine. The lease is, of course, the best evidence of what it says and what its provisions are. But then Dakota hangs its hat on this stipulation, this out of context quote in the stipulation related to an additional charge or an additional fee. Now, what the stipulation says, okay, so paragraph 8, the stipulation says, quote, the lease also requires Dakota to pay an, quote, additional fee, end quote, of 2.5% of Dakota's monthly sales gross receipts commercial activity fee. Now, it cites the two sources for that. Source number one is the lease itself, which I've stated in the brief, and I won't belabor the point here that I think on the face of the lease itself, it is evident that this is rent. But it also cites to the complaint at paragraph 8. And the complaint at paragraph 8 alleges, quote, all of the written leases between the parties required defendant to pay, as part of its monthly rent, 2.5% of its gross receipts as defined in the leases. That's index of record 1, page 2 of paragraph 8. Now, in addition to incorporating that description of what the commercial activity fee is into the stipulation, Dakota also admitted twice in both of its answers, its original answer as well as its first amended answer and counterclaim, that the leases have had provisions for monthly rent based on 2.5% gross receipts. That's the answer, index of record 17 of paragraph 8. And then again, in its first amended answer, index of record 31, paragraph 8, Dakota admitted that the lease has, quote, provisions for monthly rent based in part on the 2.5% of its gross receipts, end quote. So I suppose to answer part of your question, Your Honor, is the stipulation itself, far from foreclosing the trial court from finding correctly that the commercial activity fee is part of the rent. The stipulation and facts in the record actually support it. And Your Honor, with permission, I'd like to reserve the balance of my time for rebuttal.
All right.
Thank
you. Mr. Abney?
May it please the court, my name is David Abney, and I am appearing on behalf of Dakota Territory Tours, which I usually just call Dakota. I'd like to reserve some time, but I don't have any time to reserve, so I won't do that. I'm usually sitting over there. I made the mistake when I was sitting in my car looking at my emails, and I saw that 2 of my cases here went down the storm drain. This is, of course, a plea for pity from the court, and I feel obligated to do that on behalf of my client. The thing about the rental charges and the rent is sort of a side herring issue. If you look at the statute, the subpart E, it talks about things that a political subdivision can charge, levy or collect reasonable rental charges, but that's all in a phrase, reasonable rental charges, landing fees, and other service charges. So what you're talking about there are service charges, and the gross receipts here from the people that are using the services there, it's not a service charge. It's not in that category of items.
You know, I'll tell you why it's of concern to me, and then you can explain why I shouldn't have those concerns. You've made an equitable argument for disgorgement of past payments. But do you really have an equitable argument if your client actually benefited from the fee insertion in this lease. If you got a diminution in rental payments, actual rental payments, and then tack on the fee, and I'll call it a fee, now you're saying, oh, we don't want the fee. Well, but you've had the benefit for how many years of this process. So how can we determine what is an equitable remedy here? And I think that's what's bothering me is, do you know how much was paid? When the lease was changed to add this fee, what happened? And how can we make a determination of equity on summary judgment, which is what we're here for as well, on your claim? How can we make that determination if we don't have that information in the record?
All that's in the record is going back to at least 2012 and going a little bit further. It's about $2,500 base amount that's paid for the rent. And then they have this gross receipts thing to make up the rest of what we'll call the rental charges.
Okay, they've asserted, and you tell me if it's in the record, that was inserted in agreement with your client.
They agreed to the lease agreement, yes, sir.
In 2012.
And even before that, I think they've been running the same sort of system since the
Well, they said it was changed, and it was changed to try to equalize the payments from high season to low season.
I do not know anything in the record that explains exactly why that was done, Your Honor. But it's illegal. You can't do it. The Dakota Tours didn't realize that it was illegal until they got counsel to represent them in this particular case. And then counsel said, did you realize that this is an Anti-Head Tax Act? And they said, no, we did not. So they asked for permission to file the counterclaim. Once the case got going and they found out about this, and then they filed the counterclaim with the trial court's permission, and it went forward from there. But you can't, if you have an illegal contract, it's an unenforceable contract, and you're supposed to have restitution in that sort of a circumstance, as explained in our briefing. Just yesterday afternoon, I finally got my 3-volume set of Dobbs on remedies, which I looked at late last night, and I will file a supplement. But it really it's the same sort of argument that I've made with case law citation. This is just Professor Dobbs, in his wonderful way, distilling everything. It says you're entitled to restitution when there's an unenforceable contract under a number of circumstances, the first of which, if you're ignorant of the illegality, or if you're within the class of persons for whose protection the transaction was made illegal, and that would be Dakota, or the restitution is consistent with preventing accomplishment of the illegality, which it would be. If you don't allow restitution, they've accomplished the illegality and kept all that money. And then the last one is public policy will be served by granting restitution. And it would be here. I mean, you're not supposed to be able to benefit from illegal contracts. If there's going to be...
But that goes back to my point, Mr. Abney, assuming I agree with you on every legal point you made, now I'm just trying to figure out, on a motion for summary judgment, whether the $180,000 or whatever it was, where that figure, because all that figure is 3 years of the fees, correct?
If you go with the statute of limitations, as the
figure represents only the fees. But then we have to say, is that truly restitution if, in fact, there was an original agreement that in lieu of a diminution in rental, you're going to include the fees?
There is nothing in the record to support that at all, Your Honor. And it's really their responsibility to make that sort of record if they want to make that.
Well, you're the one who's asking for restitution, so I think it's your responsibility.
Well,
to prove that it's not, that I am entitled to all of this back.
Well, if you identify an illegal taxation, which makes the contract illegal and unenforceable, then you have a claim for restitution. Now, if Professor Dobbs deals with this last point, he says that almost all these exceptions can be brought under the umbrella rule that restitution or enforcement is permitted when the parties are not in pari delicto, that is, when the plaintiff is not in a position of equal fault, which is, I think, is what you're moving toward. But there's no equality of fault here. My client didn't know that this was illegal. The people that are collecting this money and that run the airport, they're the ones that should know that it's illegal or not illegal. But at minimum, you've got a claim for restitution that should go back all the way to the start of the illegality. That's the only way to make things equitable.
But
And
is
that-
Judge McMurdy's question then a fact question about what part of that amount really did cover what would normally be called rent, and would that cover what they say they have to get from you guys to comply with the federal law? I mean, if in fact the record shows, or there are facts out there, that you were paying $1,000 a month pre, and then your rent in the contract went down to $500 because you were going to have this extra charge of CAF, or fee, as Judge McMurdy says, then isn't that a factual determination, especially because it's an equitable remedy?
It is a factual issue, but then again, it's a factual issue for them to raise as a defense to the counterclaim, and they didn't raise it, so they waived it. In fact, almost everything that appears in the appellate briefing, which is very nicely written, it was about arguments that were waived. The one that gives me some concern is the subject matter jurisdiction about the FAA, but I addressed that pretty strongly, I believe, in the answering brief. There's no FAA regulations that deal with this, and there are cases that have allowed private parties to pursue a private cause of action. So, I mean, that's really a non-starter. To the extent you can waive it, I think it's been waived, but to the extent you get to the merits of it, there's no FAA process to deal with this sort of thing. Another thing that, well, I guess everything's bothering me today, but the one other thing that bothers me a lot is the idea that you sort of throw the trial lawyer that's represented you under the bus. You say, well, I didn't authorize him to say anything at all. Everything he said was wrong. Why did we hire that jerk to begin with? And on and on. And that's just not fair. When you're dealing with cases as a trial lawyer, you do the best you can to represent your client. You make reasonable admissions and concessions and stipulations on behalf of the client to further the client's case. From the record, it seems that what was done. This was a fairly collegial, direct, straightforward process, and the trial lawyer admitted what seems to me to be fairly obvious, that this was that it was engaged in air commerce, that it's subject to the Anti-Head Tax Act requirements, that this is a commercial activity fee, which is a reasonable interpretation of the facts in the statute, and that things were subject to subpart B4 of the Anti-Head Tax Act, and which talks about gross receipts from air commerce or transportation, which is what this was, gross receipts. So it's a temptation when you're an appellate lawyer, you come into a case and you just go, ooh, if I had just been there, I could have done it right. And that's not fair to anybody. If things are really that bad, what you have is a malpractice action. You can pursue it later. Of course, it's always difficult to do. Would the result have been changed? Who knows? But I don't think it's fair to be throwing that other lawyer under the wheels of the bus here. I think I've addressed the points, and I'm always thrilled to be able to chat with the court. If you have any questions, I'd be happy to answer them.
Good.
But if not, I'll return my time with the court and hope
All
for
right.
some gratitude for that.
Thank you.
Thank you, Mr. Ebony.
Thank you.
Counsel?
Thank you, Your Honor, and by
have 2
necessity,
minutes and 57 seconds remaining, not that I'm counting.
I will be brief, Your Honor. Thank you. I'd just like to raise 2 points in response to what Mr. Abney said a moment ago. First of which being the idea that there's no FAA process to deal with this sort of thing, to deal with a violation of the Anti-Head Tax Act. That's quite simply not true. And I'll point the court to our index on appeal, 14 CFR section 16.1 expressly authorizes a person to bring a complaint for, among other things, the requirements of the Anti-Head Tax Act. That's subdivision A2. So there is absolutely a regulatory process in place here by which the FAA, the Department of Transportation, receives complaints, investigates complaints, and if it finds that the complaint is warranted after performing an investigation, conducting a hearing, it can then issue an order, and would issue an order to the airport to correct that violation in some manner. And if the airport then refuses to do it, there's 46 USC, I believe it's 46106, that allows the Department of Transportation to bring a lawsuit against the airport in the U.S. District Court to enforce its prior order. So we're not dealing with a situation where there's simply no means to address it. There is a very clear means to address it, and that means to address it, I think, demonstrates the preemptive authority of Congress and demonstrates the intent of the legislature to remove this from courts of general jurisdiction. And I think it's also worth pointing out, Your Honor, and it was cited in our reply brief, Ainsley versus Banner Health Network. It's a 2020 Arizona Supreme Court case that we cite for the proposition that a plaintiff cannot, by invoking our equitable powers, circumvent Congress's exclusion of private enforcement of a statutory provision. That's exactly what Dakota is attempting to do here. And in response to, Your Honor, some of your questioning to Mr. Abney, I would just note, I think the court is correct in noting that there is a real problem here in awarding restitution on this factual record, because there really is no evidence on exactly what should be awarded, if anything. Obviously, our position is it should be nothing, but in the event that the court were to agree wholeheartedly with Dakota's position, there's simply no facts to show how much they're actually entitled to as part of the unjust enrichment. As it stands right now, the court's summary judgment simply awarded every dollar going back 3 years on the assumption that that was unjust enrichment, and that's simply not the case. So, Your Honor, with that, I'll yield the balance of my time.
Well, just one last question, and I meant to ask Mr. Abney, and I forgot. There was a stipulation that the 3-year statute of limitations applied below, wasn't there?
I didn't believe there was, Your Honor, if I may have a moment.
It's all right. I'll look it up.
Okay. I don't believe that was part of the stipulation, but the stipulation will say whatever it says.
Okay, thank you.
Thank you, Your Honor.
The matter is deemed submitted, and we'll issue a decision in due course.